Good morning. Thank you all for coming. We are going to start. We like to start on time so that we reward all the people that are able to be here on time. So thank you all so much for being here. Most of you know me, but for the helpers, I'm Annette Gerhardt. So I'm the person that's making this presentation today, the attorney for the people for whom you are helpers. If you have questions that are not specific to your specific estate plan, please raise your hand and I will be happy to answer questions. If you do have questions that are specific to your estate plan, please use the yellow sheet that you all have in front of you that says special concerns or requests regarding your trust, because we do want to preserve client confidentiality. And on that sheet, be sure to put your name, because it would be very hard for us to address your question or your concern if we don't know who you are. You should have a copy, as I say, of the Helper's Handbook, and if, as I say, if it was a married couple, then we gave you one copy of the Helper's Handbook, and we also should have given you a copy of the PowerPoint slides, and the PowerPoint, of course, is the contraption to my left. So we are going to be talking today about what to do in the event of an emergency, and some things not to do as well, because sometimes the things that people don't do is just as important as what they do. So the first part of the presentation is what to do when a loved one is ill, and it appears that there may be some question of that person not being able to continue to manage their own affairs. So our objectives today are for you to gain a better understanding of what to do at the right time, knowing what to do, knowing what not to do, and knowing where to go for help. The Helper's Handbook is your resource in the event of an emergency, and we're going to kind of take a little tour of this Helper's Handbook today, is to help provide you with guidance and some idea of what you can do and, as I say, what not to do. It has some answers to frequently asked questions, and we also provide some resources that are available in the community as well. And the law firm is another place to find resources. So the presentation today is divided into two parts. It's divided into what to do when a loved one is ill and what to do when a loved one passes away. So keep your Helper's Handbook in a safe place. Bring it with you whenever you come to meetings such as this, because as I said, with regard to some folks I saw walk in the door that had an older version of the book, we will change out material and put new material in there as well. There's a place where you can write your own name in the front of the handbook and who it is that you are a helper for, and there's a place in the back of the book where you can notate when you have attended workshops, because we do recommend that you attend this workshop every 2 to 5 years because of new material, and also because repetition is the key to retention. These are not concepts that you're dealing with on a daily basis, at least we certainly hope not, and so you have no reason to try to keep these at the top of your mind. So coming back to the presentation every 2 to 5 years will help refresh the information. So inside of the Helper's Handbook, there is first an introduction, a brief introduction, and then in tab 2, there's the outline for this first part of the presentation. Tab 3 contains what I consider to probably be some of the most important information in this book, which is how to get a hold of us. This is our address, our phone number, our individual email addresses. And so that team directory is perhaps one of the most important things that's in here, so that you know how to get a hold of us. Tab 4 has a set of documents in it called Letter of Instruction to My Healthcare Agent, and we call that a healthcare checklist kind of in our practice. And it also has something called hypothetical scenarios. And I'm going to go over those a little bit more in a bit. Then tab 5 has in it the outline for part 2. Tab 6 has a form called Instructions for My Final Arrangements. That's a very important document that we do ask our clients to fill out so that helpers have some idea as to what it is that people want for their final arrangements. Tab 7 has a set of sample trust settlement instructions, which kind of gives you an overview of how a trust settlement process would work. And then, as I say, tab 8 has those frequently asked questions. Tab 9 has the helpful resources in the community. Now, these helpful resources were put out by the Arizona Governmental Association Area on Aging in October of 2013. And I did check to see if they had done an update this year, which they have not. But whenever they do an update, then we will put that latest material in here. But I don't want anybody to think that we missed the latest material, because the last one that they did do was in October of 2013. And then we have a glossary of terms that is in the back under tab 10. I try real hard not to talk in legalese, but sometimes I do, and I apologize for that in advance. So the glossary of terms helps for people to, you know, what did that mean again? You can look it up in your helper's handbook. The two books that are most important here in our practice are what we call the Red Book and the White Book. So the Red Book looks like this, okay? And the White Book is the Client Trust Handbook, and it looks like this, okay? The Red Book contains the legal documents that were signed by the trust maker or trust makers. And that's what we call the people who create a trust. We don't call them grantor or settlor, because those are not very user-friendly terms. People don't use them in everyday English, and they don't find them to be, they get trustor mixed up with trustee. So we call the people who create a trust the trust maker or trust makers. And so the documents that they have signed, which are legal documents, are in that Red Book. The White Book is our Peace of Mind Legacy Planning Handbook. And Peace of Mind Legacy Planning is our trademark name for our process of the creation of estate plans and the maintenance and support of estate plans. And so that's why we call it the Peace of Mind Legacy Planning Client Handbook. That contains the checklist that I showed you a minute ago, the letter of instruction to my healthcare agent, which is we also call the healthcare checklist sometimes, and the hypothetical scenarios, and the final arrangements are contained in the White Book. So you want to know where those books are located. We instruct people not to write on the documents that are in the Red Book, because those are legal documents, and so we tell people don't write on those. If you have a question or you have a concern, something you want to change, I love sticky notes. You can put a sticky note in, you can write on the sticky note to remind you as to what it was that you wanted us to address. We can flip right to the sticky note and we can address your question or your concern. So you should ask your loved one, where exactly do you keep these books? Because that's something that you as a helper need to know so that you can find them when and if the time comes that you need to know where they are. We've also started asking clients when we send out the estate plan review worksheets, which enable them to tell us about changes that should be made in their estate plan. We have a question in there, where do you keep your books? And so we put that information into the electronic file for the client. So if you can't find them, we may know where they are. Someplace like the bottom left side of the closet in the bedroom was one that I got recently, and that possibly would not necessarily be a place that a family member, that a helper might think to look. So by having people tell us, then we may have that information as well. Now, one thing that we do is we instruct people not to put the Red Book or the documents from the Red Book in a safety deposit box. The Red Book does not have the original will in it. When we have to keep the Red Book for a little while after people sign all their documents, because we scan all of the signature pages into the electronic file that we keep for the clients. And then when we give the Red Book back, their will is not inside of the book. It's in a bright red 8.5 by 11 envelope. So I do advise people that they should put that in a safe place, like a fireproof home safe, or sometimes people have a gun safe. If they don't have a safe place in their home, then we actually advise them to put them in one of those heavy freezer Ziploc bags and put them in their freezer. Because as I say to people, if there's a fire, your refrigerator is likely to survive the fire, and if something happens to you, somebody will clean out your freezer. And so, and we don't usually need the will. Our objective, as you will see as we go through this, is to never have to use the will. And I can administer people's affairs using copies of all of their documents unless we have to open up a probate. It's very rare that we do open up a probate, but there are times when it is appropriate to do so. And for that, we do need the original will, and that's why we do have it separated from the Red Book itself. So the trust itself, the revocable living trust, is the hub of the estate plan. It is really written for helpers and for clients. It contains many personalized provisions. We've tried to write that. When I say we, I'm talking about the National Network of Estate Planning Attorneys, of which I've been a member since 2006. This document and the documents that are in the Red Book, we attempt not to use any more legalese than what we have to, so that people can actually pick it up and read it. So you can think of a trust. When a trust is created, I call it an empty box. There's nothing in it whatsoever until you put things in it. I cannot tell you how many times I have people come in for a review of their estate plan, and one of the first questions I ask them is, what is in your trust? You know what I often get? A blank look. So many times I will see what are called dry trusts, where this was a set of documents that was done by what I call one of the traveling trust salesmen. And with those types of quote-unquote estate plans, clients are expected to transfer assets into the trust themselves. And you know what happens? It doesn't happen. And so estate plans end up with usually something like the house will get in because the planner will do a deed, and so the house gets in. But then if people sell that house and buy another house, how many times does the new house get into the trust? Not very often. I see it once in a while, but mostly it doesn't happen. And then there's a bunch of stuff that's left outside of the trust. Well, there's always a pour-over will, which is the will I was talking about, that's associated with the trust that says, if I own anything at the time of my death that's not in my trust, put it in my trust. Well, okay, fine. It'll get into the trust, but the process by which it has to get there is probate. And so that's why the majority of estate plans out there, even with a trust, do end up going through probate, because typically there will be assets that are outside of the trust. That does not happen in our practice, as you will see in a few minutes, and I'll be talking about why that does not happen. So there are various assets that can be put into the trust. As you can see, we've got the house, the car, cash assets, investment accounts can all go into a trust. And that process is called funding. And it is Paulette, our funding and settlement coordinator, who's standing in the back there, waving her hands, that is the person that is involved with our clients to make sure that their assets are transferred into their trust. So the way that that happens is that for a house, for example, then we would change the title of that asset. I would create a deed, and the trust maker would sign the deed to transfer that house from themselves as an individual to themselves as the trustee of their trust. And so having assets in the trust means that those assets are titled to the trust makers as the trustees of their trust. A trust maker retains total control over all of the assets that are inside of the trust. This type of trust, a revocable living trust, has no tax effect. That means that they don't have to file a special income tax return for it. They use their own Social Security number for the assets that are inside of the trust, and they retain the right to amend or revoke the trust at any time. And we do amendments every other year. I send out what's called an estate plan review worksheet. It shows all of the decisions that were made by the trust maker at the time the plan was created or the last time that we did an update. And at every point where there's a decision shown, there's a box that says, do you want to make any changes? Do you want to make any changes? Do you want to make any changes? Also, on an annual basis, we send out what's called an asset review report. One of the first things we ask clients to do is to provide us with information about all of their assets, because I can't be responsible for getting all of this stuff into the trust if I don't know what it is or where it's located. And so we get what's called an asset detail report, and then on an annual basis we send out the information that we last knew about the assets, and we ask if there's been any changes. So in that way we have a program, a plan in place to obtain from clients the information in which they are the experts, which is themselves, their families, and their finances. And then my job as the attorney is to teach people about the law and to teach people about how the law works and what changes may have occurred under the law. And together then we create an estate plan that is really going to work for people the way that they want it to work for themselves during their lifetimes and for the people they love and care about after they're gone. And most importantly, we keep that estate plan moving with people as they move through their lives. Because if an estate plan doesn't move with people as they move through their lives, it will very quickly get out of date. And if it gets out of date, it's not going to work the way that they wanted it to work for themselves during their lifetimes and the people they love and care about when they're gone. So I've already gone through this slide. I have that tendency to do that, to jump ahead as I get on a roll. And the danger is if an asset is not in the trust, it can trigger probate or it can just end up causing all kinds of problems that we want to prevent. Now, there are some assets that should not be retitled, and you can see that the slide indicates what those assets are. Tax-deferred assets, IRAs, 401ks, annuities. Because if I were to take someone's IRA asset and transfer it from their name as an individual to their name as trustee of their trust, there would be a very bad result, which would be that it would trigger immediate taxation of that tax-deferred asset. We don't like that, so we're not going to have that happen. So we've got these assets that have to stay outside of the trust. They cannot be titled to the trust. Frequently what we will do is we will name the trust as a beneficiary of those tax-deferred assets. Sometimes we do, sometimes we don't. It's a counseling issue. Sometimes it makes sense, most of the time, especially for IRAs, it does make sense to name the trust as a beneficiary. 401ks and those kinds of plans, when someone is working, we don't generally name the trust as a beneficiary. It depends on the person's plan. But after someone leaves their employment, then the 401k can be rolled over to an IRA, which is something that we go through as a counseling issue and talk about whether that makes sense. But there are better distribution options, more flexible distribution options with IRAs than there are with 401ks. So in general, I do recommend that a rollover be done. But it's something that we go through in counseling to make those decisions. Now, there are other beneficiary designation assets, such as life insurance. Those are easy. We can name the trust as the beneficiary of the life insurance. And the reason that we want as many of the assets as possible flowing through the trust is because the trust can only control the assets that are either in the trust or are designated for the benefits to come to the trust. And as we're fond of saying, our red book is not a magic book. It's not going to sprout a smiley face and little arms and legs and run around and grab all of people's assets and get them titled to or integrated with the trust. So funding is a process that is intensively done when we first create an estate plan, but then as time goes on and things change in people's finances, funding is an ongoing process as well. As Paulette is fond of saying, funding never ends because people will change houses, they may change cars, they change financial advisors and get different accounts, and we have to make sure that those assets, as they're being moved around in people's lives, stay integrated with their estate plan. So I jumped ahead of the slide again. But there is a good point on this slide, which is be a good advocate. If your loved one changes financial advisors, or you know that they have opened up a new account somewhere, they're buying a new car, remind them to contact the law firm so that we can assist them with making sure that those assets continue to be integrated with their estate plan so that the plan does work the way people want it to work. Now, let's go on to the main topic of this particular presentation, which is disability. And it really refers to mental disability, not a physical disability. I mean, I have a client that is legally blind, but his mind is sharp as a tack, and he cracks me up all the time with his jokes. So Article 4, Section 2 of the Red Book sets forth the definition of disability, and it is, I shall be deemed disabled during any period when, in the opinion of my disability panel, I am incapacitated or disabled because of illness, age, or any other cause which results in my, and here's the important language, my inability to effectively manage my property or financial affairs. So notice that there is a new term here, disability panel. What does a disability panel do? Who is on the disability panel? Well, the disability panel consists of people that were chosen by the trust makers to decide if one of them has become disabled. And it typically will consist of two components, a medical component and family members. So an example might be my attending physician, my spouse, and my son, for example. Or it might be my attending physician, my spouse, and I ask that the people on my panel consult with my son. So then the son would not have a vote on the panel, but would be someone that the trust maker is requesting be consulted as part of the disability determination process. Now, increasingly over the last few years, as I've been talking to clients about who should be on the disability panel, we've been having quite an in-depth discussion with regard to the medical component. A few years ago now, I think it was in February of 2012, we had a client who was living independently who fell in his garage and hit his head. He did suffer a very serious head injury, and when he was found, which was unfortunately not right away, he was immediately taken over to the Sierra Vista Regional Healthcare Center, and from there he was taken by helicopter up to a level 1 trauma center in Tucson. And after that, I kind of chased him around through 3 different medical entities, medical places up in Tucson, trying to get a doctor to sign a certificate of disability. Well, as I was thinking through this whole thing as it was unfolding before me, I realized that man's primary care physician never saw him. Initially, I used to counsel people that perhaps we should use a doctor who knew you, because a primary care physician is supposed to be kind of the traffic director of someone's care. But as I say, in that circumstance, I realized the primary care physician is not going to go out of town if somebody has something arise and they have to be out of town. And I also realized that even if the gentleman had stayed in Sierra Vista, most of the primary care physicians don't do rounds in the hospitals anymore. There are doctors in the hospital that are called hospitalists that actually take care of people in the hospital. And so that's when I started to move to, how about we use the attending physician, because the attending physician is the one that is going to be right there to be able to address whether there's been a disability. Well, then there's another problem with that. If you ask many doctors if they will do a competency evaluation, many of them will say, well, I don't do that. So increasingly what we find is that the doctors that will do competency evaluations are people like neurologists, psychologists, neuropsychologists, gerontologists are the ones that we most often see doing competency evaluations. So then I started having clients ask me, well, do I have to say, can I just say that my panel can consult with a doctor or doctors of their choice? And so we have some panels that say that the people who are on the panel, the family members or friends, are required to consult with a physician or physicians of their choice. And then I had some clients that said, well, can I just say that my family members may consult with a physician or physicians of their choice? And the answer to that is, of course, yes, although I'm a little nervous about that, because that puts an awful lot of power for the determination of disability in the hands of the people that are on the panel, the family members. But I do have clients that have said, that's what I want. I want them to have the option of consulting with a physician or physicians of their choice. So that disability panel is to be found in Article 4 of the trust, and that's where we would be able to see who it is that's been appointed on the disability panel. Now, the people that are on the disability panel have one function. They have one question that they have to answer. Has the trust maker become effectively unable to manage their own financial affairs? Yes or no? The people who are on the panel do not have any financial or medical decision making in that role. Now, that's not to say that people who are on the panel may not serve in other roles. They may have several hats that they may have as part of the trust maker's estate plan. So someone on the panel might serve as a successor trustee, or as an agent under a financial power of attorney, or an agent under a healthcare power of attorney. But in the role of being on the panel itself, there is just one question to be answered, yes or no. Has the trust maker become effectively unable to manage their own financial affairs and property? So there are a series of steps in determining disability. Okay, we're going to take a little bit of, we're going to move off over to this table, and we're going to do a little vignette. Well, I'm really glad we could all get together. Mom's stroke has really thrown all of us for a loop.
I can't believe it happened.
I know. She's always been so independent. Now she can't even talk.
Oh, it just breaks my heart to see her like that.
I know. The doctors don't know how much she's going to recover, or if she's going to be able to come back home to live by herself. I'm just glad I was in Tucson on business. Otherwise, getting here quickly from Wisconsin wouldn't have been possible. Now we have to figure out how to help Mom. Does anyone know if she has any documents that appoint anyone to handle her finances or make healthcare decisions for her?
I don't know.
Well, I do know she used to have an attorney. I went to his office just recently, and he's gone.
Really?
Oh my goodness.
Yes, I couldn't believe it. I asked the people in the office and where he went, and they told me he moved to Mexico, of all places.
Really?
I guess his wife was from there, and they had family there, and so when he retired, they moved there.
Oh, that makes sense.
However, when I asked about Mom's files, they didn't know anything about her files in the office at all.
That's very upsetting.
That is.
It's not good. No, I know that Mom mentioned that she had a safe deposit box, but I don't know where it is.
Oh.
It might be at the bank where she used to have accounts, or it could be at the bank where she transferred her accounts to.
Oh gosh.
She did that a couple years ago, so I don't know. Does anyone know if she still has a safe deposit box
No.
and where it is and where the key might be?
I don't know, but you know, my attorney said that one should put estate planning documents in the safety deposit box. She had to go to court to get an order to get the documents out for someone that she is a client of
kidding.
hers.
That's not good.
Like that's not
Oh,
good.
boy.
So, but Jean, aren't you on Mom's accounts?
Well, she talked to me about putting me on her accounts, but
I
we
thought she was
just
going to do that.
we never got around to it.
Oh no.
Well, how are we going to pay Mom's bills? Who's going to take care of Daisy?
I don't know.
We're going to have to find an attorney to talk to.
I guess.
And I'm afraid we might have to go to court to get someone to be able to handle Mom's finances
Okay.
and make healthcare decisions for
For
her.
heaven's sakes.
She may have to go somewhere for rehabilitation, at least for a while. We don't know how long.
That's right.
Oh, that's
dear.
not good, because the lady at the billing department at the hospital said that Medicare won't pay beyond 100 days of care
Oh, no.
once Mom leaves the hospital.
Really?
Well, that's not very long.
No, and you know, after that, I don't know what we're going to do. I thought that Medicare took care of everything.
I did too.
Oh dear.
Apparently not.
How are we even going to pay a lawyer to figure out what to do?
Well, we may all have to chip in to hire someone, since no one can get any money from Mom's account. Jean, I know you're in school, so I know you may just not be able to put anything in, and the rest of us will just have to cover it. This is not going to be the state of your family, because you are watching this presentation. Our first segment is what to do upon a loved one's disability.